Hi there, my name is Jonathan Ginsberg. I'm an Atlanta area Social Security disability attorney, and today I want to talk to you about reasonable expectations, both on the side of the attorney and on your side as a claimant, as a client. And you know, one of the things that I find that can be frustrating sometimes in this business is that I get calls from a lot of people who have Social Security disability claims, and they want me to evaluate their case and possibly take on representation. And frankly, I would like to help everybody who calls me. If it was possible, I would take every case, even the ones I think that are very, very difficult, very, very marginal. I think everybody deserves representation. And if you truly believe that you are disabled and you've made a good faith effort to try to work and you're trying to go to the doctor, then by all means, I think that an attorney can make a big difference in helping you win your disability claim. The problem is I can't take every single case, and the reason why is because I know after doing this for 25 plus years that some cases unfortunately just are not going to be winnable. For example, if you have ongoing use of alcohol or drugs, for the most part those cases are not going to be winnable. If you want to apply for disability benefits, and let's say you're married and your spouse works, but you have not worked in 25 years, you don't have any insurance credits, then you're not going to be eligible for SSI because of your spouse's income. You won't be eligible for SSDI because you don't have enough earnings credit. Even if you are disabled, there'll be no benefits paid to you. That's not a case that I can take. If you are 22 years old and you have a badly broken arm, that's probably not going to be a case I can take because it's just probably not going to be winnable. Most judges are going to feel like at a young age, if you have a broken arm or you're pregnant, that these are conditions that are temporary in nature. And I just know from experience that very, very few judges would be likely to approve those kind of cases. And realize that from the attorney's standpoint, from my standpoint, I take disability cases under a contingency fee contract. That means I only get paid if I can win past due benefits. If there are no past due benefits, I may win, but I don't get paid. So I can't afford to keep my practice going if I'm taking cases where either there's not going to be any past due benefits or the likelihood of winning is just not there. The fee I'm paid, by the way, is 25% of past due benefits with a cap currently, in 2019 is when I'm recording this, of $6,000. Now this cap has not been changed in over 12 years. So even though other expenses in my office have gone up, my fee has not gone up at all. And again, it sounds like $6,000 a lot of money, and it's certainly not insubstantial, but when you look at, from my point of view, it's a case, when I take a disability case, that's going to be a case I've got active in my office for 3+ years. I'm paying staff, I'm paying overhead for 3+ years. I've got to pay for medical records at times. I've got to pay sometimes doctors to fill out functional capacity forms for me. I've got to be very, very careful and selective about what I can take. So first thing I would tell you is that I know people sometimes get angry when I won't take their case. It's not because I don't want to. It's because I can't afford to, because Social Security has made it where the fees are limited. We can only afford to take cases that there's a reasonable expectation of success. Now that means I will take some cases that are a little more difficult if I think there's a reasonable chance of success, if I can make it work. But again, if I don't see any way there's going to be past due benefits, or I see a huge impediment like drugs or alcohol or extreme youth, or somebody who's not worked in many, many years, that sort of thing, I'm probably not going to take it. It's not personal, it's just simply the business aspect of this, which is just unfortunate. There's no source of income, no source of fees unless we win. So when you're on contingency, you've got to be very selective. And I know people sometimes get angry. Why do you only take cases you think you can win? It's because that's how I get paid, and I've got to be conscious of that, because otherwise I can't stay in business. So I've got to take cases I think are viable. I will also tell you the things that make me nervous when I'm talking to somebody. And again, I want to pull back the curtains a little bit for you so you understand how lawyers think. I talk to somebody and they're bad-mouthing their prior lawyer. That's a big red flag. They talk about that in law school. Be very careful about taking a case or representing somebody who bad-mouths the prior lawyer, because it may be that there's good reason for it, or it may be that the client has unreasonable expectations and gets angry very easily, and you're going to be the next person he or she blames. Not every case is winnable. Not every issue is winnable. And so if a client is going to be blaming the lawyer for every problem, that's probably not somebody I want to represent. But I'll tell you, it's a big red flag. So I would be very careful about bad-mouthing a prior lawyer. If you had a disagreement, you can say respectfully, my prior attorney and I disagreed about the going forward, our strategy going forward, and I have full respect for that person, but I just can't, the way this aspect of his or her practice, it just was simply not something I could live with, so we decided to part ways. I will also tell you that if the prior lawyer will not waive fees, and when withdrawing, that's probably not a case I'm going to take as well, because if the attorney will not waive fees, then Social Security requires both the prior attorney and me, as a new attorney, to file a fee petition. That is going to take an extra year and a half to get approved with a lot of extra work. I'm not going to do it anymore, because I've had situations where I've spent so much time chasing down my fee on a fee petition that I ended up losing money on the case. So I'm probably not going to take a case when there's been a prior attorney who will not waive fees. So be very careful about dismissing your prior lawyer. And if you do dismiss the prior lawyer, you want to ask that person, would you be prepared to waive fees? And quite frankly, if the other attorney had put in 2.5 years of work and done a lot of work, I wouldn't blame that person for not waiving fees. But again, that means you're going to have a difficult time finding somebody new. So again, be aware that financial considerations do drive representation from the point of view of the attorney. I think if I talk to somebody who's got an ongoing alcohol or drug problem, that's going to be something that's going to make me very wary, because most of the time those cases are denied. A person who does not go to the doctor, who's got big gaps in medical treatment, those cases very, very difficult to win. A person who's working under the table for cash, or who's using somebody else's Social Security number, I'm not going to take that case, because I won't perpetuate any fraud on Social Security. It's just not worth it to me. I'm not going to reveal it. I'm not going to broach confidence, or breach the confidentiality, but I will not take that case. I'm going to be very reluctant to take a case when my potential client tells me that his or her doctor won't cooperate, does not believe in the concept of disability. If a person's already gone to a hearing and lost, and there's nothing new, I'm probably not going to take the case, because you're not going to get a different result. In fact, if it's the same, you live in the same place, it'll go back to the same judge. So if there's nothing substantially new, you haven't reached an age milestone, or there's not new medical evidence, then it's not going to be a different result, and I'm not going to take that case. A person who argues with me, I've had sometimes people will tell me that I'm wrong in the way I analyze my cases, or this is the theory that they want to go under. Well, again, with all due respect, if I'm the lawyer, I'm going to be the captain of the ship, and I'm not going to I can't let somebody else tell me how to practice law. So if somebody feels that they know more about the theory and the arguments for disability than I do, all the more power to them, but I'm not going to take that kind of case. And I think I would also tell you that I'm reluctant to take cases for claimants who are very, very young. Someone who's, somebody who's in their 20s or early 30s. Very difficult to win those cases. Not impossible, and it depends on the medical condition, the diagnosis, and their associated limitations. But those are cases I'm going to be reluctant to take. So the bottom line is that I look to take a case where I feel like my client has a reasonable understanding of what to expect. If I have a client who expects to be called every week with an update, not going to take that case. That's not reasonable in a 3-year representation. But somebody understands that they're going to hear from me every 4 or 5 months. They can email me at any time or talk to my paralegal periodically, but will recognize this is a long haul and will act reasonably and will cooperate with me. That's the kind of person I'm looking to represent. Somebody who presents a different attitude, or again, drug-seeking behavior or some sort of fraud, I'm not. So again, I think you need to have reasonable expectations when you meet with an attorney, and the lawyer has to be able to express what he or she expects from you clearly. But I want you to know the way lawyers think, and that is that we want to help everybody, but we have financial constraints that limit what we can do, and that's just the fact of life. It's not always fair, but don't expect a lawyer to take your case when there's no chance of getting paid, because again, this is a difficult enough practice. It's hard enough to find winning cases, but it's just very difficult to do pro bono work in a disability context because there's too much involuntary pro bono is maybe a good way to put it. So those are the expectations I've got for my clients, and again, I think the clients should have reasonable expectations of me. I think when somebody calls me, I think it's reasonable to ask me how I approach cases, how I develop evidence, what a theory of the case would be. Have I had previous experience with that particular medical problem? These are all legitimate questions to ask, and there should be an ongoing dialogue. You should feel comfortable that your lawyer understands what's going on with your case, knows the limitations that you are describing, and has a good argument to be able to make on your behalf, and will be there 100% for you. That's what you should expect from your attorney. And there are many very good attorneys in the Atlanta area. If I can be of assistance to you, please reach out to me. I'm at 770-393-4985. Let me know what you think. If you think I'm reasonable or unreasonable, leave me a comment on YouTube or on Facebook. And visit my website, ssdanswers.com/Atlanta. I've got a free Secrets to Winning Disability Survival Kit there. Also a place where you can ask me for a case evaluation. So hope you found this helpful. Again, I'm Jonathan Ginsberg, and I do wish you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.